First of all, welcome to all of you. Thank you very much for coming to the California Initiative Forum here at McGeorge. I'm very happy that so many people turned out. This is an important civic duty that we all have to vote on these propositions, and I appreciate everyone coming out to listen to the reports that the students have worked really hard to put together. They've looked with a lot of detail at each of these propositions, and we're happy to share the information and research that we've done with you. My name is Mary Beth Moylan. I'm the Associate Dean for Experiential Learning here at McGeorge School of Law. I've been teaching the California Initiative Seminar since 2003, and since that time we have been doing every 2 years, and sometimes more when we've had special elections. We've been producing the California Initiative Review, and we've been having public forums about the ballot propositions, the statewide ballot propositions. I'm especially happy tonight to see here some alumni of the California Initiative Review. It's like a very exclusive club, and there are quite a few of you here, so thank you for coming out and supporting. I know you all know that it's a little nerve-wracking. Well, thank you. Also, we are live streaming this, so I want to welcome everyone who is watching live stream. And I know some of you who are here might think, well, who would be doing that? But we know that at least 3 of our mothers are watching. An answer portion of this. Oh, another alum has just come in. Yay. Okay, when we get to the question and answer portion of this, the folks who are watching us live stream will be able to type in questions, and we'll hopefully be able to get to some questions both from the room and from the live stream. I'm going to ask now the 2 students who will be collecting the question cards for the first few ballot measures to actually pass out some more of the question cards. Some of you might not have seen them when you came in. So I want to give you a little bit of a background of how we're going to run this evening. The students who are here are all part of my California Initiative Seminar class. What you should have grabbed up at the top are 2 publications that we produce from this class. One is a complete report called the California Initiative Review. The other one is the At a Glance. The At a Glance has 1-page summaries of the more complete reports. If you did not get a chance to get one of those, we may be running a little thin, but we're still handing them out up there. We're covering all of the statewide ballot propositions tonight. So that's props 1, 2, 3, 4, 5, 6, 7, 8, 10, 11, and 12. Okay, so we are not covering Proposition 9. All we have to say about that is that it was removed from the ballot by the California Supreme Court because the people of California, interestingly, do not have the power to unilaterally divide ourselves into 3 states. So I'm not going to go into detail, but there are a lot of California constitutional provisions and U.S. constitutional provisions that would prevent us from doing that through the initiative process on our own. So as one of my students said, and I did say the other morning on Insight, 7, 8, 9, okay, that's very funny. So, plan for the evening. We are going to have each pair of student authors come up. These are all co-authored reports. They're going to talk to you about the proposed changes that each proposition makes. They'll go over the pro and con arguments for each, and then we are going to do this in kind of groupings. So we'll talk about all the bond measures first. That's propositions 1 through 4. Then we'll take questions on the bond measures. Then we will move on to propositions 5, 6, and 7, which is a segment that I call taxes and time. And then we'll take questions on those 3. Then we'll present 8, 10, 11, and 12. And I have no clever moniker or common theme for those. So I'm sorry, but those are just 4 propositions that we'll talk about and then take questions on. So we're going to get started because there's a lot of ground to cover tonight. If we don't get to your question, I'm going to apologize. We'll try to get to as many questions as we can during the question and answer period. But in order for the live stream thing to work, I will have to read all the questions so that they're picked up by the mic and are going out on the live stream. So do ask your questions on the cards, and we'll get through as many as we can. We're going to start with the bond measures, which are propositions 1 through 4. And before we get into proposition 1, we're going to get a little primer in general on bonds by student John Knoble. Come on up, John.
1 through 4. So for these propositions, they're all using what we call general obligation bonds. Now, these are bonds that California, if we pass the proposition, is going to commit to repay with all legally available funds. These are different than a revenue bond, where the bond is paid back from the revenue from what the bond is going towards. So something like a dam that is producing hydroelectricity that is funded by a revenue bond, the sales from the electricity would pay that back. In propositions 1 through 4's case, we are going to repay the bonds through the state's general fund. Now, this is important to note because the interest rates for the bond and what we end up having to pay back ends up being slightly higher than what the bonds fund. For example, currently we have a high grade credit rating, about an A- as far as everybody's concerned, whereas during the recession we had a low medium grade. Now, this matters because it affects our interest rates. If a state that had the highest credit rating versus us with a low medium grade credit rating, say if we had a recession or something happened within the legislature where we're not managing our funds correctly, for every $1 billion borrowed, we'd have to repay about $200 million more compared to the state with the highest credit rating if we had the lower credit rating. I note this because currently California is on the hook for about $33 billion in bond-related debt. We've been passing these bonds for a while now, and while we have been paying them back for the most part, it is something to note as we go through propositions 1 through 4. So with that, I'm going to turn it over to John and Henry for proposition 1.
Policy considerations. So proposition 1 is the Veterans and Affordable Housing Bond Act of 2018. It will authorize $4 billion in state bonds to finance existing affordable housing programs and the CalVet Home Loan Program. $3 billion will go towards the Affordable Housing Program that's administered by the California Housing and Community Development Department, and the $1 billion would go towards the CalVet Home Loan Program that's administered by the California Department of Veterans Affairs. Finance existing affordable housing programs that have previously been financed by state bonds. Specifically, voters have passed Proposition 46 in 2002, which authorized $2.1 billion towards affordable housing. And in 2006, voters passed Proposition 1C to find $1 billion for this program. The home ownership program would provide homeowners structures such as parks, sewer, and transit near urbanized infill areas. Proposition 1 would allocate $300 billion to farm worker housing programs that assist in the construction and rehabilitation of rental and owner-occupied housing for farmers. And finally, Proposition 1 allocates $300 million to Local Housing Trust Matching Grant Program that provides matching grants to local governments and nonprofits that raise money for affordable housing. Proposition 1 would also allow the legislature to reallocate proceeds from these bonds among these programs as necessary to effectively promote affordable housing in the state. The cost of the $3 billion housing bond, according to the to the LAO, would be about $170 million annually for 35 years for a total cost of $5.9 billion. So that's the affordable housing portion. Now, the $1 billion state bonds for veteran homes would finance farm, home, and mobile home purchase assistance for veterans through the CalVet Home Loan Program. A little bit of history. CalVet has generally been financed through state bonds. The Veterans Bond Act of 2008 was the last bond measure that financed CalVet, providing $900 million. In 2014, voters passed Prop 41, to repurpose $600 million out of the $900 million to help veterans rent affordable housing. According to the LAO, they don't anticipate any direct cost to the state because monthly loan payments to the state have generally covered the amount owed to these bonds. And now I will pass it on to Mr. Henry Mantel to discuss about the policy considerations.
Hello. So there are pros and cons. The proponents of Proposition 1 want to make sure that you are aware that there is a housing crisis in California. There are 2.2 million low-income renter households across the state, and they are competing for 664,000 affordable rental homes. There are about 4 to 5 in 10 households spend 30% or more on housing costs, and that's according to the California Budget and Policy Center. And then according to the U.S. Census, there are about 50,000 homeless veterans in the United States, and in California we have about 12,000 homeless veterans. The proponents insist that that if we pass Proposition 1, investing in the existing housing programs will benefit California's homeless and low-income earners, as well as foster and at-risk youth, persons with disabilities, the elderly, and farm workers. And $1 billion will go directly to veterans housing, making sure that veterans have affordable housing and are not homeless and don't end up on the street. And the proponents also cite numbers that say that Proposition 1 will create 137,000 new jobs and pump $23.4 billion into the state's economy. And the other arguments, they say there's some disagreement on this. They say that the money borrowed from the past propositions, as John mentioned, has already been spent. The numbers are a little skewed on this one. The most recent auditor's report said there was about $200 million left as of this September, and but they say that if this money runs out, then there will be affordable housing programs that go unfunded, and that will do a lot of damage to low-income earners and people who need affordable housing in the state. And the supporters are numerous. There's a long list of unions, cities, businesses, and veterans groups that are supporting Proposition 1. And in contrast, the people who are opposing this proposition are insisting that California already has too much debt. California has about $74.2 billion in general obligation bond debt, and Proposition 1 would result in payments of $200 million annually for 35 years to pay it off. And they also mentioned that the money from the last initiatives has not completely run out, so borrowing more before we spent everything would be irresponsible. And there aren't a lot of opponents to Proposition 1. The Howard Jarvis Taxpayers Association, which is generally very against government borrowing for anything, has not taken an official position against Proposition 1. However, their president, John Kupel, has, and the gentleman who wrote the ballot argument against Proposition 1 is named Gary Wesley, who has made it his mission since the 80s to write an opposition argument for every ballot initiative that doesn't have one. So take that as you will. To conclude, a yes vote on Proposition 1 means that the government will issue $4 billion in bonds to fund housing programs. A no vote on this measure means that the government will not issue the bonds and the housing programs will receive no extra funding. Thank you.
Hello, my name is David Whitkin, and this is my partner, Kaylin Huang, and we're going to be discussing Proposition 2, which is the Use Millionaires Revenue Tax for Homelessness Housing Prevention Bonds Measure. Now, there's going to be 3 main points regarding Proposition 2 to fully understand what's happening. The first one is that we have to consider Proposition 63 in 2004. We also have to consider AB 1618 and AB 1628 from 2016, and then also AB 1827 from 2018. Now, as I mentioned, we'll have to go back in time to 2004, where Proposition 63 was passed, establishing the mental health Services Act. And what that did is it charged millionaires a tax of 1% on all income over $1 million. And they collected that money for the purpose of funding the Mental Health Services Act, and they put that money in the Mental Health Services Fund. Now, an audit in 2015 revealed that there was a surplus of the funds from Proposition 63, and that there was some mismanagement of that proposition in the law pertinent to that proposition. So what happened is, in 2016, the legislature decided to try to use those surplus funds to establish the No Place Like Home program to engage in the homelessness prevention housing effort. And so what happened was AB 1618 and AB 1628 were challenged in court on constitutional grounds, the first of which is that because the ABs were amendatory to Proposition 63, that they had to be amended through the initiative process. And the second was that even though they categorized the money that they were issuing to the No Place Like Home program as revenue bonds because it was using the Proposition 63 revenue, it was in fact a general obligation bond because it attached to the taxing power regarding the millionaire's tax from Proposition 63. So now moving to 2018, on June 27th of this year, Governor Jerry Brown signed into law as urgency legislation AB 1827. Now AB 1827 makes up sections 1 through 7 of Proposition 2. What that does is it satisfies both of the constitutional questions regarding the Assembly bills from 2016, because not only does it properly amend Proposition 63 by initiative, it also, because it was urgency legislation, had the general obligation bond passed by 2/3 of the legislature and now is properly put before the voters. And so my partner, Kaylin Hong, I do realize that this is very complicated, and you'll have an opportunity to ask questions later. So Kaylin Huang is now going to explain the opponents and proponents' positions.
So the proponents for Proposition 2 have a few major points. One is that the biggest obstacle for mental health patients that are homeless is that lack of housing. It keeps them in dangerous situation. It keeps them in that unstable lifestyle. Building affordable housing and housing dedicated to them will help their recovery. In particular, for California's housing crisis, this proposition will build 20,000 affordable housing units. So again, as David mentioned, a lot of the money for Proposition 63 is just sitting there, and a lot of local governments aren't quite sure how to fully spend it. So this would be a great way to help mental health patients and push them towards recovery. So Proposition 2 will not only fund money for housing and the physical buildings themselves, it would also fund better support throughout the entire process, so not only healthcare and doctors, but also law enforcement. Now, the opposition is pretty clear. It's a bond act, so it's going to cost a lot of money. It's going to increase our debt. A lot of people also say that Proposition 63 money should stay with Proposition 63. The voters already voted on the goals, and we should follow what we originally intended to do with the money. Now, a lot of the proponents for Proposition 2 also are the people who are going to get a lot of the money. In particular, a lot of the money is going to go to administrative fees, to construction companies. So that is something for everyone to consider. And finally, Proposition 2 will not solve legal barriers such as zoning law. So how fast the actual buildings can be built remains to be seen.
So a yes vote on Proposition 2 allows $2 billion in bonds to be distributed to the No Place Like Home program for the purposes of homelessness prevention housing, and that money will be repaid primarily by the surplus funds from Proposition 63. Now, a no vote on Proposition 2 prevents those $2 billion in bonds from being released and waits on the court case that's currently pending regarding AB 1618 and AB 1628 from 2016, and allows the court to determine whether it was constitutional for the legislature to release that money.
Proposition 3 is the Water Supply and Water Quality Act of 2018. This is an $8.8 billion sale in general bond obligations related to water and environmental projects. In the past 18 years, $31 billion have been sold in bonds related to water and environmental projects. The money within Proposition 3 goes into 7 different categories. $2.4 billion will go into watershed lands. This is land that is in the forest area where the rain falls, and so the money will be used to gather as much rain out of whatever falls in that area. $2.1 billion will go into water supply. This is increasing any infrastructure that needs to be updated or investing in recycling, desalination, and upgrading disadvantaged communities' water supply. $1.4 billion will go to fish and wildlife habitat. This is money for salmon, fish, other critters in nature that need to have updated habitat. $1.2 billion will go for water facility upgrades, specifically related to canals or any mechanisms that move water from where it is to where it needs to be. No money in this provision or in this section will be going towards dams. In fact, $500 million will be going towards the removal of a dam. $1 billion will be going towards groundwater research or research related to the 2014 groundwater sustainability law that was passed by the state. There'll be investments in making sure that our groundwater is sustainable. And then finally, $500 million will be going towards flood protection, specifically related to levee updates or repairs related to the Oroville Dam disaster. I will now turn it over to Kevin with policy and fiscal considerations.
Thank you, Sebastian. So the Legislative Analyst Office came out with a projected fiscal impacts report for Proposition 3. The principal amount of Proposition 3 would total $8.9 billion. It would take about 40 years to pay off. Each year, annually, it would cost the state $400 million to pay off both interest and the principal, adding a total of $17.3 billion when everything's said and done to the total amount of state debt, which is about 1/3 of 1% of the general fund budget. Most of the money will go to local agencies who operate and maintain these water programs. It'll save local agencies around $200 million per year for the next few decades. Now on to the proponents and the opponents of Proposition 3. Most of them are water-related agencies and advocacy groups. The proponents' arguments are pretty simple. In general, the proponents argue that Proposition 3 is a necessary step towards tackling a variety of water issues in California, such as drought preparedness, providing safe drinking water to millions of Californians, including those in disadvantaged communities, increasing mountain water runoff capture and repairing existing canals and dams, as well as improving groundwater sustainability and quality. A driving force behind their arguments is that Proposition 3 is a necessary step towards circumventing the federal and state legislative processes and allows voters to tackle these issues straight on. In particular, proponents argue that it will increase access to clean water, restore dams, canals, and increase water supply reliability for both surface and groundwater. And with that, I'll turn it over to Kaylin, who will tell you all about the opponents to Proposition 3.
So the opposition for Prop 3 consists of a taxpayer group and the Sierra Club. Of course, it's a bond act. So again, increased debt and increased interest payments that California taxpayers will have to pay. In particular, it does not solve California's main problem, which is the chronic lack of water, because this proposition will not build new dams or new infrastructure. The opposition also points out that it does not follow the beneficiary pays principle of water for California. In general, any water projects, whoever benefits will pay for it, but in this situation, regardless of where it is, all of California taxpayers will be paying for it. The opposition is also against California allowing so much water to run into the oceans and into parks, devoting so much to wildlife when we do need that water. And finally, $4 billion of the money is going to disadvantaged communities, but the opposition says that we do not know who or what constitutes disadvantaged communities. So, in conclusion, if you vote yes and the proposition wins, then the state will be able to sell almost $9 billion of general obligation bonds to fund the water projects you've just heard. If the answer is no, then the state cannot, and local governments will have to figure out other ways to fund these projects. So, the choice is in your hands. Go vote.
Okay, hello again. So, the Proposition 4, the Children's Hospital Bond Act. Oh. There we go. Okay, so, Children's Hospital Bond Act. To get to the bond, I want to first talk about two initiatives before this because they are more or less the same thing. This is the third time that California is going to be voting on bonds for children's hospitals. The first two in 2004 and 2008 have been passed. The first one, 2004, Proposition 61, allocated about $750 million in general obligations bonds to 8 nonprofit children's hospitals and 5 University of California children's hospitals. For the University of California hospitals, they got about $30 million each, and for the nonprofits, they got about $74 million each. How they split up the funds is based on the allocation of beds at each hospital, so more beds, more money, and there's really not much squabbling between the hospitals for the money, so it seems like everybody is fairly happy with the funding they have gotten. Now, the bond funds specifically go to capital improvement projects, which are things like building a new wing of the hospital, upgrading your medical equipment, things that take a lot of capital to actually do. So now we have 2008, Prop 3, that was $980 million. Same thing, it goes to 8 nonprofit children's hospitals and 5 University of California children's hospitals. For the 2004 bond, all of that money has been spent. For the 2008 bond, all the money hasn't quite been spent yet, but it's been earmarked for projects. So the projects of building a new wing have been approved. They know they're going to do it. The money's already tied up in something. Now, Proposition 4 builds on that by allocating $1.5 billion in general obligation bonds to children's hospitals for capital improvement projects. Now, the noticeable differences are obviously the amount of money, and they added another category of hospitals that can receive funding. Those are CCS, California Children's, what's the last word? Services. So it's essentially a general hospital that has a children's wing, so we're getting money to them as well. They apply to the funds through through a state agency, essentially asking things like, what is the money going to go to? Is the project shovel ready? Is it going to help the outcomes of sick children? So overall, though, the $1.5 billion will actually cost the state about $2.9 billion because of interest. And with that, I'm going to turn it on over to my partner, Peter.
Hi, everyone. I'll be talking about the proponents' arguments for Proposition 4. So these large projects done for these children's hospitals require a massive amount of funds to execute. And when these hospitals rely solely on money given to them by the legislature, it can change as, legislative budgets are not very stable, depending on year by year. So these large 30-year bonds allow for them to do these very massive projects like building brand new children's hospitals, and the proponents argue that this allows for better outcomes for children, especially sick children. In the voter guide, they give a statistic that it has led to an 85% rate of victory over leukemia for children because of the money that has been given to these hospitals. We weren't able to verify if this was actually the case or this is just the worldwide standard of medicine kind of raising the bar and kind of battling leukemia. And we'll stand over to Sarah now.
Thank you. So I'm here to present the opponent's arguments for Proposition 4. I'm not going to get too much into it because a lot of the opponent's arguments are the same as the other propositions, but there are 4 questions that are posed for voters by the opponents in order to, for people to think about when they're deciding if they're going to vote for or against a bond measure. The first is the current debt the state has before the proposition is approved. The second is the expected cost of the state for the bond, which would include the potential interest. The third is the proposed uses for the money. And the fourth one is if the voter feels that a specific proposition is a good use of the state's money, and that's what you should base your vote on as to whether or not you're going to vote for a general obligation bond measure.
Okay, and with that, a yes vote on this measure is going to authorize $1.5 billion in general obligation bonds for capital improvement projects for Children's Hospital. A no vote is not going to allow that $1.5 billion for capital improvement projects, but it will avoid about $2.9 billion in state money going to interest and the bonds. Thank you.
Okay, now we're going to have some questions for propositions 1, 2, 3, and 4, and all the students who did reports will be here and ready to go. Now, people are still coming through collecting questions, and so I am going to start with one that I can read. Okay. Penmanship counts here. Okay. So this is a question for Proposition 3. Thank you. The question is, Proposition 3 costs $400 million per year to repay, but saves current water programs only $200 million a year? Question mark. Anybody want to take that one?
Sure. I guess the question sounds a little confused. Every year after, if Proposition 3 is passed, it'll take $430 million a year to pay off the interest and the principal. But because most of the money from Proposition 3 goes to fund local agency projects that handle water-related projects, those local agencies save money because that money is coming from the state instead of their own coffers. I hope that helps.
While you're there, which dam is being removed?
It is not being removed per se. It is the Magita Dam down in Ventura County. It is, money is going towards the removal, and so it'll take a long process to remove it all the way. So it doesn't remove it all the way, but it helps to remove the Magita Dam down in Ventura.
Why?
Yeah, okay. So the dam had an original capacity of 7,000 acre feet. It's been silted up. It was built in a bad area that wasn't designed well for dams. And so by 2020, it'll have 0 capacity. So their plan is to remove it, allow fish to go back and critters to go back into the habitat.
Okay. We have quite a few that are kind of general bond questions, and so John, I'm going to ask you this one because I know you know the answer. Are the bond interest rates fixed when issued, or can they fluctuate as interest rates change?
Okay. I'm going to give a half answer to that because I know the half answer. The bonds end up being sold through big investment banks like Charles Schwab, Wells Fargo, that sort of thing. So when the bond is actually sold, yes, the interest rate is fixed, but the bonds are released as the projects are approved. So we'll have a project approved in 2019 that may have one interest rate and one approved in 2020 that could have a different interest rate. So I hope that answers your question.
Okay. We also have quite a few asking what the total debt is right now and what the ratio of debt is. We had one question early on that was confused because I think that in Proposition 1, there was a reference to there being $33 billion in debt, and then there are other references to 72 or 74 billion in overall general obligation bond debt. And the answer there, I believe, John wants that one too. All right.
So I think what the confusion was trying to prevent that is the 70 is all of the bonds totaled. The 33 is the interest for those bonds.
Okay. Proposition 3, we have quite a few relating to whether or not the bond funds to be reallocated, or will they be in any way related to or applied to the Delta Tunnel project?
The answer is no. There could be some auxiliary things, cleanup habitat that could come parallel to the tunnels, but the answer is no.
So we have quite a few also of Prop 1, some Prop 1 questions. There's one asking if the legislature may allocate funds among the housing programs in Prop 1, or are there restrictions on the allocation, and how will it be ensured that it's restricted only to housing?
So unlike the previous state affordable housing bonds, Prop 46 and Prop 1, there is language provision in Prop 1 that will allow the legislature to reallocate, the programs that I've highlighted. They can reallocate some of the allocations that's on the proposition later on, as long as it's within the purpose of promoting affordable housing with the state. So there is a provision for them to reallocate those funds.
Yeah, that was good. Okay, so this one asks, how do Proposition 1 and 2 coexist if they both provide for low-income housing? I think that David would like to take that one, wouldn't you?
Sure. So the best way to think about this is actually an idea that our wonderful instructor came up with, is to think about it as a Venn diagram. So the Proposition 1 is providing certain services to homeless veterans, and then also Proposition 2 is providing housing for homeless individuals with mental health issues. And obviously some of those homeless veterans will also be individuals with mental health issues, so there will be some overlap for that group of people getting funding from both propositions. But in general, it wouldn't be much of a conflict. And further, the individuals that are receiving the double funding would be just homeless veterans with mental illness.
Okay, we're going to give one to Prop 4. I think every proposition will have had one. That'll be good. So Proposition 4, private hospitals do not get these funds. Why should public? Is this a good use of state funds? Now, I'm going to just go out on and say, the students have studied these. They're not going to tell you, though, whether it's a good use of funds. That's your decision to make based on the facts. We're trying as best we can to provide the facts. So we do objective and neutral. Okay, but you can answer the first one about private hospitals versus public. You want to do that one?
So I'm going to answer this from the perspective of the CHHA, the California Children's Hospital Association, who ended up writing this bond measure, saying that I don't know, but the way they wrote it, there's not argument between them about why certain hospitals get it, so they've resolved that internally. And they seem to be happy with it, so.
Okay. Do you want to add, Peter? Go ahead.
Many of the nonprofit hospitals that do receive funds are private institutions. The Stanford Children's Hospital, the Loma Linda Hospital, they're all private institutions. It just is a matter of what kind of services you provide to children that qualify you for these bonds.
Yeah, that's a really important note. The other thing that they usually note, but I told them to go really quick because of our time constraints, but Sarah usually mentions in the opponent's side on the Children's Hospital Bond Act, which I think is just worth noting, is that the funders, if you go and you look, the beauty is we have all sorts of great disclosure laws. So you can find out who is putting money in for all of these propositions, and I encourage everyone to do so. The Secretary of State's website, sos.ca.gov, like help, California.gov, is really a very good interactive site. You can find out that there's Cal Access is linked there, which shows you who's funding the various measures. And largely, the proponents of Proposition 4, almost entirely, right? Entirely, are the people who will be receiving the bond funds. Okay, so all the hospitals have put in like $500,000 each at least. One has put in over $1 million. What's that? Okay, thank you to my husband. Each of them put in 1.3. And so they've all put in a lot of money for this bond act, and they're going to see a large return on it. But I think that, again, that's not illegal. There's nothing wrong with that per se, but it's information that I think is a fact that people should think about and know. Okay, thank you all very much. We're going to move on to 5, 6, and 7.
Hello everybody, my name is Megan Shiner. We are going to be talking about Prop 5, which is the property tax initiative, property tax transfer initiative, sorry. So currently California collects property taxes from property owners based on the value of your property, and then you pay a tax based on that value. And this tax revenue creates funds for local governments. So currently, the law allows certain eligible homeowners to transfer this property tax base to a new home with certain limitations. And then the eligibility requirements are anyone that is a homeowner over the age of 55, an individual with severe disabilities, or their home was destroyed by disaster or contamination. And the limitations on the transfers currently are that it can only be done once in your lifetime. You can only transfer within the same county. There are 10 counties that allow out-of-county transfers, but the counties must have agreements with each other that allow it. And the replacement property must be of equal or lesser value. So Proposition 5 would change the limitations on these transfers. You would still be required to be an eligible homeowner. Proposition 5 would remove the limit on how many times you can transfer. So if you've already moved once, you're over the age of 55, you'd be able to move again. You'd have no limitations on that. You can transfer as many times as you'd like. You would no longer have a limit on where you can transfer, so you can move anywhere within the state of California, and your replacement property could be worth more than the original home value. And I will pass it over to John to talk about the policy considerations.
Sweet. Okay, so because we are allowing people to transfer their tax base an unlimited number of times if they're above 55 and buy more expensive homes, there can be a fiscal impact to the counties who really rely on property taxes for things like schools, fire, police, all your basic county services. Now, there are 2 reports looking at the fiscal effects of this proposition, because what fun would it be if there was one and it was clear what was actually going to happen. So the first one is done by the Legislative Analyst's Office, which is a state agency that analyzes initiatives as well as different bills for the legislature. Now, they estimated that they would the state would start losing about $100 million in the first year, growing to $1 billion in 10 years. The second report, done by BRG, assumes that there's going to be new construction because of this proposition. So if there is new construction, the counties would end up, or the state would end up getting about $159 million in the first year. And that BRG report only analyzed the first year of the proposition. Now, the difference in that funding comes from the methodology of each study. The LAO uses what we call static scoring, which doesn't look at people as economic actors that who could change because of the proposition. So they're just looking at the dollars and cents, less people less property taxes within the county means less funding. Now, the BRG report uses something called dynamic scoring, which assumes that people are economic actors and their behavior is going to change because of this proposition. Specifically, the behavior that's going to change here is that more housing is going to be built because there's a demand for housing now that people are moving more. So it's not necessarily that one is more legitimate, than the other. It's just that the dynamic scoring, and I should point out, the dynamic scoring from the BRG report was funded by the California Association of Realtors, who are the ones doing Proposition 5. Now, that's not to say that this report is not credible. Dynamic scoring is used by Congress. The people who run BRG are a former LAO director as well as a former elected official, and overall they're fairly credible. So if you tend to be more fiscally conservative and you're concerned that maybe this isn't going to change people's actions, you might want to look at the LAO report. If you think this could influence people's action and more housing could be built, you might want to look at the BRG reports. They're both educated guesses, so it's really up to you to decide what you think is the best way to go forward with that. Now, for the proponents of this measure, the California Association of Realtors, they are arguing that this is needed because seniors can't afford to move. They've either used their transfer once, they want to go out of the county they're currently within, and they're stuck in inadequate housing because of that. They also say that disabled people are stuck in inadequate housing and they need the ability to move multiple times. Disaster victims are penalized because you have to stay within your same county to keep your tax base, which is fair. If your home just burned down, you might not want to buy a house within the same area again. And then it's going to increase economic activity because of the building, and it's going to open up more housing because people are going to be moving out of their houses, downsizing, new families can move into the houses, that sort of thing. Now, the opponents are concerned about the fiscal effects. These are the California Teachers Associations, the associations of counties, the people who are going to be directly hit by that loss in funding if it occurs. They oppose it because they are going to lose money, and there's going to have to be money pulled from the general fund to support education if the counties lose money because of something called Proposition 98 that essentially guarantees a certain level of funding for the counties. They specifically note that about 20% of county budgets are based on property taxes, so any major change could have pretty drastic effects county to county. They also argue that because you're allowed to transfer 55 and above, 55 really isn't the age for seniors anymore. People are working longer. I know I'm not retiring anytime around 55. But the California Association of Realtors argue back that a lot of teachers, firemen, policemen end up getting their pensions around that time. That's when they want to start retiring. So again, kind of a judgment call on everybody's part to decide if 55 is really a good age to put this property tax transfer at. And with that.
And just to conclude, so a yes vote will allow eligible homeowners to transfer their property tax base to any home of any value in any part of the state as many times as they want. And a no vote will keep everything as it is, so no changes will occur and the same limitations will stay in place. Okay, still here. So now we're on Proposition 6, which is the voter approval for increases in car and gas taxes. So last year, SB 1 was passed, which increased California's funding for transportation. It included 4 new taxes and fees. One is a 12 cent increase in gas excise tax, which was effective in November of last year. There is a transportation improvement fee that ranges anywhere from $25 to $175, which went into effect January of this year. There is a 20-cent increase in diesel excise tax, which will go into effect next year. And there is a $100 fee on zero-emission vehicle registration, which will go into effect July of 2020. So revenue from these taxes and fees will provide California $4.4 billion this fiscal year. And the taxes and fees, as you can see, since they are implemented at different times, at full implementation, they will produce anywhere from $5.2 to $5.4 billion annually, and 2/3 of that is specifically distributed for maintenance and rehabilitation of local streets and roads, and that is mandated by the California Constitution. So Prop 6 would change these, and it would effectively repeal SB 1, eliminating any gas or vehicle tax that was implemented, and it would eliminate all of the revenue from those taxes. It would also amend the California Constitution to require voter approval for any new or increased taxes on gas or diesel fuel taxes in the future.
So now we'll look at the policy arguments for and against Proposition 6. The proponents of Proposition 6, who want to repeal the gas tax, argue that this will return the California fuel and vehicle taxes to the pre-2017 levels where they were less expensive. If you haven't noticed, the last few months, your gasoline prices have kind of gone up quite a bit, but it's been going towards these SB1 funded road improvements and things like that. So the proponents also argue that this tax actually affects the middle and lower class the most, as middle and low class people tend to have to drive to their job every day, and they're the majority of the economy that's on the road, and they also don't make as much money. These increased gasoline costs and and vehicle taxes cause the most amount of economic harm to these groups of people. They also argue that it is also very expensive to live in California as it is, so with these increased taxes, it makes it even more difficult. And they also, a large argument on their side is that this proposition changes the Constitution to make all future gas taxes be approved by a popular vote after it's passed the legislature, which they think is a very important part of how we take control of the taxes that are levied against us. The opponents of Proposition 6 argue that repealing SB 1 through this proposition would cost the state billions of dollars in revenue that could be applied to our crumbling infrastructure. Right now we have tons of roadways and bridges that are in dire need of repair and have horrible ratings of safety, and repealing SB 1 would effectively bring all of these projects to a halt. It would get rid of 68,000 jobs that are being produced through these infrastructure projects, and it could also cancel over 6,500 different transportation projects that are both local and statewide. The opponents of Proposition 6 have a very strong argument that Proposition 6 could cause constitutional issues. If you repeal, the United States Constitution and the California Constitution both have clauses that say that no statute can impair the completion of a contract. And so all of these jobs that are being created through these SB1 taxes, since they are contracts formed with the state, if SB1 funding is taken away, it could impair these contracts severely and then cause the state to have to pay for all these contracts on top of canceling the funding that they receive from SB1, and it could create a myriad of problems in the future.
So in conclusion, a yes vote on Proposition 6 will eliminate all the taxes and fees that were implemented by SB 1, as well as their revenues, and the California legislature would require voter approval to impose any new or increased gas and diesel fuel taxes in the future. A no vote on Proposition 6 would keep SB 1 taxes and fees in place, as well as their revenue, and the revenue would continue going towards projects to improve roadways and highways. Yeah, that's it.
So Proposition 7 is the proposition that sets out to conform California daylight savings time to federal law, and that it suggests that it would allow the legislature to change daylight savings time. I'm going to start off by giving you a little background to explain how this got here. In 1949, California voters passed Proposition 12, and that established Pacific Standard Time as the time zone for California. They, after that, passed another initiative changing the dates a little bit. But then in 1966, the US Congress passed the Uniform Time Act, and what that did was actually set nationwide daylight savings time with different dates from those that are in California. So under the current law in California, that's written in the government code section, it says that daylight saving time ends the last Sunday in September, whereas under federal law, which is the law that we are actually under because of the Uniform Time Act and because Congress passed it, it's actually the first Sunday in November. So we have on the books different dates from what the federal government set, but that doesn't change the fact that we still follow the federal government's laws. So a thing to notice about this is actually a legislative initiative, unlike a lot of, or I think all the other initiatives that we're talking about. This doesn't come from people going out and collecting signatures. This comes from the legislature. They passed the bill and it was signed by the governor, and then that's how this got on the ballot. And the reason they're doing that is because the California Constitution requires that, since this was originally an initiative, the only way to repeal or amend it is to pass another initiative that the voters get to approve. So with that, I'm going to let Sarah talk about what the proposed law would do. So first, it's important to note that Proposition 7 does not change daylight savings time in California to be year-round. This may confuse voters because both the proponents and the opponents focus their arguments on the benefits and disadvantages of year-round daylight savings time. The proponents and opponents' arguments are framed around Section 1 of the proposition, but they don't address what Section 1 or the other sections of the proposition actually do. So Section 1 of Proposition 7 gives the legislature the ability to further research and consider the effects of year-round daylight saving time in California. It's possible that the legislature will use this vote to say that the majority of Californians will want to go to year-round daylight saving time during their future research and consideration, which may be why the proponents and the opponents are focusing on this argument. Section 2 of the Proposition 7 actually implements these changes three changes, excuse me, that are required by the voter initiative process to repeal it. So the first change repeals the parts of the Daylight Saving Time Act that require the voter initiative to happen in the future. The second update is that the language of the current California Daylight Saving Time Act will be updated to match the Uniform Time Act, so we'll no longer have this discrepancy between the dates in the California law and the Uniform Time Act, which is best practice to have those statutes match. The third change is that it gives the legislature the ability to petition Congress for California to go on year-round daylight saving time in the future. And the legislature is only going to be able to petition Congress to do this if they have a 2/3 vote from the legislature, which again, this kind of goes into why, or might be why why the proponents and the opponents are focusing on this year-round daylight saving time benefits and disadvantages so much. So to move into what the proponents and the opponents argue, the proponents, as stated before, focus their arguments on the benefit of year-round daylight saving time. The benefits they focus on are public health and energy saving. The proponents cite a number of studies that show there's an increased chance in heart attack, at-work injuries, and other public health risks on the Monday after the time spring forwards at the start of daylight saving time. The proponents also state that there'll be energy savings because there'll be a decrease in electricity use and fuel consumption. However, a study that was cited in the legislative history said that there was not an increase in energy savings when they did a study in Indiana. So it's unclear how the proponents actually calculated the estimated energy savings, though it might vary throughout the diverse regions of California. There are other public policy considerations that the proponents did not address. The first is, like I said, it's best practice for the state law to match the federal law, since we have to follow the federal law anyway. And second, the voters no longer have the ability to change daylight saving or any time laws in California because of the Uniform Time Act. So repealing the voter initiative will enable the legislature to update California law if there are any future changes to the Uniform Time Act by Congress. And so with that, I'm going to turn it over to Anna.
Okay, so what you can see up there is the current map of the United States with the time zones that we have. The opponents make a number of arguments. I think the most powerful one is that if we were to, eventually, if the legislature were to decide to put us on year-round daylight saving time, we would be out of sync with the rest of the country. And that's a pretty strong argument because if you look, you know when the East Coast is 3 hours ahead, and they would have to, for example, if you were writing contracts, they would have to change, you'd have to be aware of the fact that sometimes California is now 2 hours, different, and sometimes it's 3, and you have to keep that in mind, and that's one of the best arguments. And we'd also be no longer, on the West Coast time with our neighbors in Oregon and Washington. Instead, we'd actually be in the exact same time as Arizona because they do year-round standard time. So that is an interesting thing. Additionally, the opponents argue that it'll be dark in the morning in winter, in late, and more so than it is now, right? So with daylight saving time, it is going to be light late December, Christmas morning at 7 a.m. And if we were to do away with it, it wouldn't be light until 8 a.m., which means that school children will be waiting for, the bus in the cold. People will be driving to work when it's dark as opposed to, people still probably driving to work in the dark, but that actually leads to the next argument, which is that it would increase accidents because more people would be commuting in the dark. Finally, they point to the fact that, like in 1973, this was tried during the energy crisis, and it was so unpopular that it didn't even survive the term that they had set. They tried to do 16 months, and instead, after 10 months, people were like, we don't like this. So
a yes vote for Proposition 7 would repeal the voter initiative aspect of the Daylight Saving Time Act. It would allow the legislature to update the language of the current law to match the federal law, and it will allow the legislature, to do further research and consider moving to year-round daylight saving time with the permission of Congress.
And a no vote would mean that nothing would change because we still have to follow federal law. And the existing language would remain incorrect in the government code, and the legislature could not change to daylight savings time without future voter approval.
Okay, on to taxes and time, and while some of the questions are still coming down, I have to apologize for my slide in which I misspelled Megan's name. So it does have an H, and I know she has family here, so I apologize to them. It's correct in the printed volumes. Okay, a lot of the questions that I have received thus far, I would put into the category of statements. And so maybe there are some questions here. Well, this one at least has a question mark. Okay. So I actually thought what I might do is, because I do think that there is value to hearing other people's thoughts and ideas about this. So I thought I might spur some discussion by reading a few of the statements, and then maybe the students, maybe if we can find one that's really a factual question in here, we can get to that. Actually, there is one Prop 5 factual question. It asks, what about special assessments, property taxes, Mello-Roos, for example, are these excluded? And I'm pretty sure the answer to that is that, go ahead.
Yeah. So every property tax levy is the state 1%, which is what the property tax measure is specifically dealing with. It also has any bonds that local counties have passed that can get added to that, as well as special districts. So I do not believe it would be affecting the special district property taxes.
Yeah, that's my understanding. Okay, good. So let me read some of the other Prop 5 ones, and we'll end with one that's kind of a question. So one statement is, most people over 55 tend to move from congested areas to more rural areas. This would place an undue burden on rural counties' infrastructure and public safety providers due to lower tax base and higher population. Thank you. One is if seniors move out of a home and then new owners should pay more property taxes, how realistic is it that seniors would buy more expensive homes when they can't afford to move out of their current home because of taxes? Okay. I mean, I think the question assumes that seniors are strapped, but some are not, right? So, and this one relates to that. Why not limit to $1 million and lower cost homes? So that's kind of a retort to the last one of they're strapped for cash, right? So this doesn't limit it. It doesn't matter if we're talking about wealthy seniors. And again, as John, I think, pointed out, 55, is the new 35. So really, anyone over 55 can buy a home as expensive as they want and get the benefit of the tax base. And then the final Proposition 5, I think, statement, isn't Prop 5 a $1 billion giveaway for 85,000 people who might be millionaires? Doesn't it blow holes in an unpredictable manner in county and local budgets for schools, police, fire, public works, etc.? Think about it. Okay. All right, I think that's Prop 5. Any other comments on that? No? Anybody? Okay, good. So, are we missing somebody? No. Oh, you're a double. Okay. Okay. So we have a lot of questions on Prop 6 involving how the gas taxes have been spent in the past. Are they really used for what they're saying they're used for? Questions about whether we're allocating the gas taxes in the way that we're supposed to be. I think that is a question. It comes up again and again. Is funding from SB1 designated only for road and bridge repair? So I'm going to let you guys talk to a little bit about that, okay?
So I cannot speak to how the taxes have been spent in the past. That was not anything that we found during our research. But the revenue that comes from the taxes and fees from SB1, 2/3 of that is going to be used for rehabilitation and maintenance of roads and highways, and that is mandated by the California Constitution. So there is a provision in the Constitution that says 2/3 of the revenue from these fees has to be used for those purposes only.
What about the other third?
The other third goes towards different infrastructure projects. It's like for bus lines and for creating of other infrastructure as opposed to just repairing the roads.
Yeah. I think the other thing to remember is, and some of you may have recalled this, right? We did just actually vote in June to further target the ways in which SB1 funds were going to be used. Does anybody remember voting in June? It's a long time ago, right? But, so do you want to speak to Prop 69? Yeah, actually there's a question about it. Does Prop 69 apply to all gas and vehicle fees, or just the taxes related to Prop 6?
I'm not sure about the first part, but yeah.
Okay, but it definitely relates to the
So,
SB1.
according to the research that we did, all of the SB1 taxes will be stuck in a certain spending kind of structure created by Proposition 69 that we very strongly voted into action back in June, and it's basically the same that we've been saying before, that the large amount of it is going to go towards local and statewide repair of roads, and then the rest of it goes towards infrastructure in general.
We also have a question here about Prop 6. Can you speak to the response to the initiative's title and it being allegedly misleading? So, can I take it first? Yeah. Okay, thanks. So some of you may have gotten a mailer in the mail that said it was an official ballot correction. Did anybody get that on a white piece of paper? Official ballot correction. The title is really repeal the gas tax or something to that effect. So that was not an official mailer at all. Okay, and if you read the fine print, it was not an official mailer. So I just want to speak a little bit about to how the process for the titles and the summaries and how they come about. The Attorney General's office drafts the official ballot title and summaries. They do it before it circulates. They do it again before it goes on the ballot. The students in my class had a guest speaker from the Attorney General's office who described this process in great detail. The Attorney General's office takes a neutral crack at telling us what the proposition will do, and if there's a problem with it, there's an opportunity for it to be challenged in court. And sometimes ballot titles and summaries are challenged as being deceptive or misleading, and courts will rule on them. There is a great deal of discretion placed in the Attorney General as an independent constitutional officer in the state. And so, but it is not usually the Attorney General, him or herself, who in the first instance is doing the drafting. It's usually a civil service attorney working in the Department of Justice who does the first drafts. So as far as I think we are aware, the Proposition 6 title and summary is an accurate description of what this initiative does. And I think that there is a lot of misinformation going on, including that mailer, which was in fact misleading, said it was an official ballot correction change. Just so everyone knows, that's not how the Secretary of State would do something. Hey, by the way, people, change your ballot? No. So that was not real. Okay. Any for Proposition 7? Do we have any cards at all for Proposition 7? No? Okay. Nobody is worried about daylight savings time. But the children waiting at the bus stop in the dark. I do want to really stress one additional point, and Sarah said it, but I just want to underscore it. If Proposition passes, then the voters will never be asked again to worry about conforming daylight savings time to the federal law. Let me say that again. It won't come back if we vote yes. Okay, that's all. Objective and neutral, objective and neutral. Okay. I think we've talked about that. We've talked about that. I think we're good. Okay, we're moving on to Proposition 8, fair pricing for dialysis. Anoop and John.
All right, good evening, everyone. Today we will be discussing Proposition 8, the Fair Pricing for Dialysis Act. First, I'd like to begin with some background information. There are two dialysis companies that operate a majority of the dialysis clinics in California, about 70%. And these companies contract with both government and private payers. The contracts with government payers are regulated by statute, and the contracts with private payers are not. And so this allows the companies to charge private payers up to 3 times as much as government payers. And now on to the proposed law. Proposition 8 would require clinics to issue refunds for any revenue above 115% of allowable cost. And this includes direct patient care services and healthcare quality improvements. This would also require clinics to submit reports to the California Department of Public Health And it would also prohibit clinics from discriminating against patients based on their insurance status. And now John will discuss the policy considerations.
Hello again. I'll be presenting the arguments, the proponent's arguments for and the opponent's arguments against the Proposition 8. Proponents include SEIU, United Healthcare Workers, International Brotherhood of Electrical Workers Union, and the California Democratic Party. The proponents argue that by requiring corporations to refund excess profits that are used to improve patient care, it will lower dialysis treatment costs and incentivizes clinics to spend more on patient care services and healthcare improvement costs. By linking revenue to direct patient care services, dialysis corporations would have strong incentives to invest more in patient care services. Proponents also argue that it would ensure clean and well-maintained clinics because clinics would spend more on health quality improvement costs that is tied to their revenue. On the opponent's side include the dialysis corporations, the VITA and Fresenius, the California Hospital Association, and the California Republican Party. Opponents argue that clinics will operate at a loss because reimbursement rates will be too low and it doesn't cover the actual cost of operating the clinic. They argue that the allowable cost that's defined in the proposition is too limited. It does not cover critical staff and necessary services to operate the clinic. Consequently, they argue that clinics will be forced to close, and with less dialysis clinics, patients would be forced to seek treatment in more expensive hospital emergency rooms. Opponents also argue that the proposition presents constitutional issues which will give rise to post-election challenge. And if the proposition passes, and there is a post-election challenge, and this proposition did have a pre-election review, so there is potential that if it passes, there might be a post-election challenge. There are a couple of issues that would potentially be litigated. First issue is whether the rebate provision of Proposition 8 is a taking of private property. It's a taking if government regulation completely deprives the clinics of economically beneficial use of their property, which is, in this case, their profit. On one hand, the revenue cap does appear to deprive clinics of their profit, but on the other hand, proponents would argue that revenues are not limited because more money spent on allowable costs would actually increase their profit. If the courts find that there is a taking, the next question is there fair legal proceedings to grant clinics due process if the revenue cap is too low and it deprives them of fair return? Proponents would argue that there are fair legal proceedings under the section 1226.7A6 of the initiative. Clinics can go to the court to propose a replacement revenue cap if they can argue that the revenue cap deprives them of fair return. Opponents argue that giving the court this authority, this power, instead of an administrative agency would violate separation of powers, and that the relief granted is inadequate because it is only effective for 1 year. So in conclusion, a yes vote would limit dialysis clinics' revenue and require them to refund revenues above the 115% allowable cost, and no vote would not limit dialysis clinics' revenue for non-government payers. Thank you.
Proposition 10 is the Affordable Housing Act. Proposition 10 shifts rent control from the state to local municipalities. Rent control, it is key to mention that Proposition 10 does not implement rent control. It just shifts the rent control, the ability to rent control, to allow for rent control to cities and municipalities. So what Proposition 10 does is repeals Costa-Hawkins Act which was a legislative act. It was a grand compromise in the early 90s that was thought to take care of out-of-control rent control at the time. At the heart of Costa-Hawkins are four issues. Housing constructed after 1995 must be exempt from rent control. New housing already exempt from rent control that was in place before February 1, 1995 remains exempt. And single-family homes, condominiums, must be exempt from rent control. And rental property owners must have the ability to establish their own rental rates when dwelling units change tenancy. Within Costa-Hawkins is also, outside of Costa-Hawkins, within the courts is this notion of a fair rate of return. This is a legal term of art that allows landlords to maintain a fair rate of return on their investment within their property when they're renting it out. Indifferent of, well, taking a step back, if Proposition 10 does pass, the fair rate of return is now within the California Code of Regulations. But if it is not passed, it is still exists with the through the courts. And so that leads to some legal issues that could occur if Proposition 10 passes. The fair rate of return will become something that will be litigated over. This is a heavy fact-intensive analysis that basically balances the interest of the landlord and the tenant, taking in a multitude of factors, including inflation, value of the property, equity, investment, and many other factors. If rent control were to come in place, that would probably lead to a lot of litigation figuring out what that dollar amount is. Secondly, there is an issue with takings and if rent control is considered a taking. Jurisdictions across the United States are split, and the Supreme Court of the United States has gone both ways. The California Supreme Court upheld rent control as constitutional and not a taking. The New York legislature implemented rent stabilization, and the Second Circuit ruled that that was not a taking, and the Supreme Court declined to hear that case. With the new Supreme Court makeup and how the court is shaped now, it remains to be seen if they take it, and if the Supreme Court takes a case now with respect to rent control, and if they rule it as a taking. Now to turn over to the policy considerations, Henry.
Hello again. Again, I'm Henry, and again, I am here to remind you that we have a housing crisis in California. The proponents really want to make sure that you're aware that the housing crisis is real, and low-income renters are really suffering because of it. A UCLA study has shown that the rising cost of housing has been a substantial factor in the increase in homelessness, and California's median rates are higher than any other state in the country. On top of that, as I mentioned earlier, more than half of renter households put more than 30% of their income towards rent in 2015. And as a result of this, workers and employees are being forced to live further and further away from where they work, which increase costs by increasing transportation, gas, and a bunch of other issues. And again, the proponents want to make sure that you know that this passing Proposition 10 doesn't actually impose rent control. It simply gives the local governments the authority to do so. So it gives them one more tool to deal with the housing crisis, how they believe it should be dealt with. And the supporters include some unions, or a good amount of unions actually, from the California Teachers Association, the California Nurses Association, and the SEIU. The Democratic Party has also endorsed Proposition 10. However, not all Democrats have endorsed the measure. And the Sacramento Bee and the LA Times have come out in support of it. On the other side, the opponents insist that rent control will simply make the housing problem worse. They believe that the real solution is to build more housing, not restrict rents. They say that restricting rents will give developers no incentive to build new housing. It would restrict their ability to make a decent rate of return on any developments or new properties by restricting how much they can charge for rent. And the new regulations on rent would mean higher costs, which would be passed on to other non-rent controlled housing units. And also rent control would lead to a decline in property value, which would in turn lead to a decline in property tax revenue, which would hurt local governments and how much money they have at their disposal. And as Sebastian mentioned, this would, I think they're right about this would likely open up a lot of legal challenges. It is really the question of whether or not rent control is constitutional has never been decided by the Supreme Court. And it could be considered unconstitutional under the Fifth Amendment as an unconstitutional taking of private property. And again, what a fair rate of return is would also require a lot of litigation. And the opponents, in the proposition, there is a section that states that requires taxpayers to pay the proponent's legal expenses if the initiative is challenged, and it likely will be. So taxpayers may be on the hook for some of those legal costs. And the opponents are actually Gavin Newsom and John Cox have come out against the proposition, including 27 California newspapers. We just got that number updated. And the California Chamber of Commerce and also some unions. So to conclude, a yes vote on Proposition 10 would mean that state law would no longer limit the kinds of rent control laws that cities and counties could enact. A no vote on this measure means that state law would continue to limit the kinds of rent controls that cities and counties could have. Thank you.
We will be discussing Proposition 11, the Emergency Ambulance Employees Safety and Preparedness Act. First, I would like to note that this proposition only applies to private sector emergency employees, which would be EMTs and paramedics. It does not apply to emergency employees who work for public agencies. Until recently, the longstanding industry practice for emergency employees was to remain on call. However, in 2016, in Augustus v. ABM Security Services, the California Supreme Court ruled that on-call breaks violate state labor law. The court held that California labor law prohibited employers from controlling how employees spend their break time. The Augustus court determined that employers could not require private security guards to keep their radio devices on during their breaks and respond to calls as necessary. And due to the similarities between the private security guards and the emergency employees, it is likely that the Augustus decision would apply to the emergency employees. There are two areas of federal law that are relevant to this proposition. One is the Fair Labor Standards Act, and it establishes employment standards that affect private sector employees in federal, state, and local governments. And two is the National Labor Relations Act, which has jurisdiction over all matters related to unions and collective bargaining. And now on to the proposed law. Proposition 11 would allow employers to require employees to remain on call during their breaks. It would require emergency providers to manage staffing levels, and it would also provide employees with paid training for certain emergency incidents, such as natural disasters, violence prevention, and mental health and wellness education. Additionally, this measure would require employees to offer their employees access to mental health treatment services. And lastly, this measure would absolve ambulance providers of liability and also carve out an exception in labor law to allow certain employees to have interrupted breaks in exchange for compensation. And now for the policy considerations. The proponents of this measure believe that 911 emergency services will not be delayed because emergency employees would be required to remain on call. They also believe the measure would provide important training for emergency incidents. And now on the other side, the opponents believe that the measure would negatively impact labor workers and exclude private sector workers from labor protections. And now David Whitkin will discuss the constitutional issues.
There are several potential challenges that Proposition 11 may incur. The first of which is under the Supremacy Clause of the Federal Constitution, where state law conflicts with federal law, that state law will be preempted, meaning it will be voided by the federal law. So here there's both a conflict and a field preemption concern. I'll start with the field preemption concern first because it's more likely to be a successful challenge. So the National Labor Relations Board essentially controls all union matters within the United States. So to the degree that Proposition 11 interferes with the jurisdiction of the National Labor Relations Board, it would be preempted on those grounds. And further, federal law under the Federal Labor Standards Act allows employers to have individuals on call without compensation. However, this proposition would provide an exemption for employers to force certain, well, I guess contractually, I mean, they have a job, but they would have to be on call for compensation during their breaks. Now, the reality is that could present a potential conflict preemption issue, but because it's likely that you could comply with both laws simultaneously, because the federal law doesn't prevent you from allowing the employees to be compensated for the interrupted breaks, then the conflict preemption challenge would likely fail. And then there's also an ex post facto clause concern under the Sixth Amendment, generally applied to criminal issues. Laws that are retroactive, that are punitive in nature, may violate the Constitution. Civil laws also have, where their purpose or effect is punitive, then those laws could also be challenged under the ex post facto clause. However, here it's unlikely that the elimination of the employer liability and because of that elimination of liability, essentially eliminating some of the employees' claims they could potentially bring, would not rise to the level of an ex post facto violation in the civil context. Further, under the California Constitution, it could potentially incur a single subject rule challenge because the employer liability elimination provision really doesn't have much to do with the health and safety issue. However, where any type of statutory scheme is, or I should say, in this case, an initiative scheme, is germane to a single purpose, which is broadly construed, that measure would survive such a challenge, and this measure likely would. Further, there could be a potential severability if something were to be found unconstitutional, any portion of the bill were to be, or the initiative were to be found unconstitutional, then if the voters were sufficiently focused on the portions that are constitutional, we can sever the unconstitutional portions and keep the constitutional portions in place. So essentially a yes vote on this measure would eliminate the employer liability for any labor law violations incurred between the Augustus decision in 2016 and the passage of the proposition. Further, it would allow for employers to have individuals that are doing emergency services for private companies on call during their breaks for compensation. Now, a no vote would prevent the carve out in labor law exempting these emergency service employees. It would also force ambulance companies to raise their staffing levels by 25% to cover the staggered breaks, and it would not eliminate the employer liability. Thank you.
All right, everyone, the one you've been waiting for. Let's talk about chickens. So Proposition 12 is the Prevention of Cruelty to Farm Animals Act. Before we get into what Proposition 12 of 2018 does, it's necessary to understand Proposition 2 of 2008, if any of you all remember it. It was the California voters' first attempt at regulating farm animal cruelty through the initiative process. And what Prop 2 did was it set certain size requirements on cages and containers for egg-laying hens, breeding pigs, and veal calves. The size requirements were that essentially the animals would have to be able to fully extend their limbs, stand up, sit down without touching the wall of the container. Proposition 2 had been challenged for being unconstitutionally vague because of that standard. It had also been challenged for violating the Commerce Clause and Supremacy Clauses of the United States Constitution. While the courts have held that Prop 2 is not unconstitutionally vague despite the standard, the courts have not held whether or not Proposition 2 violated the Constitution, Commerce Clauses, and Supremacy Clause. But getting back to Prop 12, some claim that Prop 12 will remedy some of those issues from Prop 2, and others say the same problems from Prop 2 will exist with Prop 12. And I'll hand it over to Annalisa, who will tell you all about what Prop 12 does.
So Proposition 12 sets forth specific size standards that Prop 2 failed to do. So for example, egg-laying hens would have 1 square foot of floor space, and calves would have 43 square feet. You can see there's kind of a gradual phasing in of this that would occur. So that's one of the biggest things, is just setting forth these specific actual size requirements as opposed to the turnaround kind of vague standard. Additionally, what it would do is ban the sale for anybody who knowingly sells any animal products that come from animals that are not raised in compliance with the new standards. They would be subject to misdemeanor penalties or fines. Then also, so that's kind of one of the changes, is this ban on the sale. And that ban applies, it's important to note, to out-of-state animals that don't comply. So if you tried to sell non-conforming products, even if they came from out of state, the ban would apply to them. The language of this proposition requires that any amendments to it would require a 4/5 vote of both houses of the legislature, and also that any amendment must be consistent with and further the purposes of the act. That's a very kind of high bar in terms of amending it. It could still be amended, but it would be harder. It's a pretty high standard to meet. But it wouldn't necessarily have to come back to the initiative process. Another thing to note is that, as we have talked about, I think the last presentation talked about things like preemption and the ability of the federal government's laws being taking precedence over state laws. So there's a possibility that there would be a challenge if this were to be found not in compliance with a federal law that specifically would prevail over California law. And as Kevin mentioned earlier, again, the interstate commerce with that ban on the out-of-state sale could be another grounds for challenge. Importantly, the proposition contains a severability clause, and that means that if parts of it were found to be unconstitutional, the existing parts would still remain in effect. So now I'm going to talk about the proponents' arguments as to why they are proposing these changes from the Proposition 2. The Humane Society of the United States, the American Society for Prevention of Cruelty to Animals, and veterinarians are among the biggest groups supporting this piece of legislation. And they argue that it would prevent cruelty, that the previous standards don't go far enough. Additionally, health concerns, they say that this would reduce the risk of salmonella because of the standards for the chicken cages. And finally, they argue that it would increase jobs because, for example, the chicken industry is large in California, and complying with Proposition 12 would have businesses hiring more people to have more humane chicken facilities.
And I'll tell you what the opponents think. The opponents, here's a head scratcher, the PETA, the People for Ethical Treatment of Animals, are actually opposing Prop 12. They're arguing that it's less space for chickens and more years of cages. Basically, they argued that Prop 12 is a failure because it only requires 1 square foot of space per chickens. That's not enough. They say it doesn't prevent animal cruelty, and because for chickens those size requirements wouldn't go into effect until 2022. They say California was supposed to be cage-free in 2015, and this just prolongs a cage-free California until 2022. Secondly, opponents argue that food's going to get more expensive. They argue that farmers are going to have to comply with these size requirements, and that the money that farmers are going to have to incur and spend in order to comply is going to get passed down and trickle down to consumers in the stores. And lastly, opponents argue that it's unconstitutional for similar arguments that opponents have made to Proposition 2. They argue that Californians don't have the right to force out-of-state farmers to comply with California's unique social agenda and unduly burden interstate commerce. And that's under the Commerce Clause of the United States Constitution. That argument will be brought forth. And under the Supremacy Clause, opponents argue that Proposition 12 is essentially null and void because right now, House Bill 2887 is on its way through Congress, which, as proposed, would prohibit states from regulating out-of-state businesses unless those businesses have a physical presence in the state. Now, whether or not that passes, we don't know, but if it does, opponents argue that it will make Proposition 12 null and void under the Supremacy Clause. Prop 12 is really easy. If you vote yes, you vote yes to increasing size requirements on cages and containers for breeding hens and pigs, as well as veal calves. And secondly, if farmers and ranchers don't raise these animals in compliance with these new standards, it will make it a crime for farmers and ranchers, both inside and outside of California, to sell those products in California. And a no vote just keeps current size requirements as they are. Thank you.
Okay, we have quite a lot of questions, and really excitingly, we have some from our online viewers. So, and it's not all just from my mom. Okay. In fact, I don't think any of them are. She's probably not even watching any longer. Okay. Okay, so I'm going to start with one for Proposition 8. There are quite a few asking about the likelihood that the passage of Prop 8 will result in further limits to dialysis capacity, concerns about closure of dialysis facilities, and overburdening hospitals with dialysis patients. So, and another one in a similar regard asks, is it possible that passage of Prop 8 would result in a decrease in care or services to dialysis patients? And while you're answering that one, Prop 8, I'm going to add on, does Prop 8 limit government payers too, or just private payers? That's a quick one you can answer first. Did you get that first one?
Let's go with the second one first.
Go with that one first.
Yeah, so does it limit government payers or just private payers? The proposition only limits non-government payers because for Medi-Cal and Medicare, those are already regulated by the federal and California government.
Okay, so now the question is about the possibility of a decrease in care or services, or are we going to be overburdening hospitals with dialysis patients? What's the likelihood of closure, I think, is what people are concerned about.
That is a bit harder to answer because there is the LAO, the Legislative Analyst Office, did say that the fiscal effect is uncertain. And it's because the uncertainty is whether, well, there are two uncertainties. One uncertainty is the definition of allowable cost. If they define the cost as broad, then the clinics will not adjust their cost structure as much. So there might not be a lot of changes. If the allowable cost is defined narrower, then clinics might have to change their cost structure. They might close, or they might increase their allowable cost. If they do that, then they don't have to close. Or they might have to go and to the court and ask for an increased revenue cap. So those are the uncertainties. So because we don't know how the allowable cost will be defined, and we don't know how the clinics will react, we don't have a definite answer for that.
So this actually leads, we're going to do one more while you're up here, John. Stay right here. You're going to like this one. Why is Proposition 8 on the ballot? Isn't this too complicated for the voters to decide? Read in the cards.
What's the thing? Objective and neutral, right? Okay.
You don't really have to. Yes, it's
Yes,
very
it
complicated.
is.
Yes, complicated.
Yes, it is complicated. That is true. Thank you. Yes.
Go, Anoop. Yes, Anoop has an answer.
They have tried to pass it through the legislature as a bill, and so the people are bringing it as an initiative.
Because it didn't pass. Okay. All right, on to Prop 10. This is an online question. Is it possible or likely that if Proposition 10 passes, it could have the opposite of its intended effect by decreasing the supply of rental housing?
Yes, that is actually the opponent's main argument, is that rent control would have the exact opposite effect of what the proponents say it will, and will actually make the housing crisis worse.
I don't know if you know the answer to this one. Let's see. Another online one. If cities implement rent control options, assuming Prop 10 passes, what recourse would landlords have if that caused them to lose money or not be able to charge enough rent to cover their costs?
So landlords would still be allowed a fair rate of return on their investment. They would still be allowed to charge a certain amount of rent. What a fair rate of return actually is up to debate and probably up to litigation. So that is something that would probably go through the courts. And so it's really difficult to tell right now what that means.
I think that's right. Okay, Proposition 11. The question is also from online, what % of emergency workers are private and directly affected? Would this proposition have a greater impact on certain districts?
I'm not familiar with exactly the number of how many are private versus how many are public. However, there are many private emergency medical technicians. A lot of the ambulances that are servicing the people of California are sent out by the private providers, and so the impact would be relatively significant, either if they have to increase their staffing by 25%, or if they have to pay for all of the services under Proposition 11. However, if Proposition 11 were to pass, whatever the cost that, basically the private ambulance providers are the main proponents of the proposition, so they've already kind of calculated how much they can absorb, and I think Proposition 11 is to some degree an olive branch, saying we can absorb this much cost to improve these services and to cover the breaks, but they feel they can't absorb the 25% increase in staffing.
I know you talked already about the federal labor law. There's a question here about how federal labor laws would impact the proposition's validity. I think that was answered during your main presentation. But can you speak to another question, which is what is the standard for public emergency responders? Are they on call during breaks?
So as I mentioned earlier, federal labor law does allow for individuals to be on call during breaks without compensation. So states can do as they wish regarding their own laws, provided they don't conflict with the federal laws. As I mentioned earlier, this law would, you'd be able to comply with both laws because federal law doesn't mandate that you have to keep employers on call during breaks without compensation. So California, the court was the one who decided that this was violative of California law. And so what other states do, we did not research that, but regarding other states, it's pretty much guaranteed that because the federal law allows them to be on call without compensation during breaks, that other states have that approach as well.
Thanks. All right, we're going to turn to a Proposition 12 question. How would Proposition 12 reduce the risk of food poisoning? California agricultural industry is already heavily regulated, and how does spacing change that? Spacing does not relate to food safety at the processing point. I feel like that's an Annalisa question.
So the argument from the proponents is that basically salmonella will be reduced because of the better housing for the chickens.
Go ahead.
Basically, the cages that are being used currently, they argue, are tied to salmonella and food poisoning, and they're saying that by adopting the new requirements, that this would be less of a problem. It's not entirely 100% clear exactly.
Okay. Another Prop 12, as a practical matter, are farm county DAs prosecuting any cases under Proposition 2 right now?
No. And when we researched Proposition 2 from 2018, most of the people challenging it were state attorney general offices. I don't know about local counties, but it's on a much higher level than that. Maybe they are, I'm not sure. So I'm just gonna say no.
Okay. Okay, we have just a few minutes left, and I actually, there are several more kind of specific questions. I want to give, I want to be mindful of everyone's time, and I would like to answer two kind of last, more global questions. One came in from an online viewer, and one is from here. So the one from here is, can you talk about who sponsored the initiative for the ballot? I'm not sure which that goes to, but which initiatives were put on the ballot by the legislature? So I do want to take a minute to talk about that, because a lot of these are voter initiated, but some of them have been placed on the ballot by the legislature. So I think it's a good question and important to note that Proposition 2, which is the transfer of the mental health services money, or the millionaire's tax, to be used for other purposes, was put on by the legislature. Proposition 7, the Daylight Saving Time Act, was put on by the legislature. And anybody else's? Just those. Prop 1, the Bond Act, the Housing Bond Act, was put on by the legislature. So, and I do want to note as well that 4 of the measures are changing or altering previous voter-initiated measures. So we are back to the public and to the people to have a vote because we put things on in the past. Dating back to the Daylight Savings one in 1949, Proposition 5 amends Proposition 13 from 1978. Proposition, what did I just say? No, nope, not 1. 12 is Proposition 2 from the previous farm animal cruelty one. We have to amend through the initiative process because it came about that way. 2, 5, 7, 12, 2, because we're amending the Mental Health Services Act. So 4 of them are related to prior initiatives. So we do, we ensure our ability to vote in the future by voting now, is one way to say that. So I just think it's important as we vote on initiatives to be mindful that they come back to us unless they do something like Proposition 12, which is to give authorization to the legislature to change it in the future consistent with its purpose. Of course, Prop 12 only gave that permission to the legislature if it gets a 4/5 vote. Yeah, okay. I know you all can do math. Okay, that's a hard standard. Okay, so the final viewer question that I want to read is, what message would you convey to students as they approach voting age beyond the midterm election? And so I guess the message that I would like to leave everyone with as we conclude our proposition forum is that there is an obligation as you become an adult and as you participate in society and in our community to be an educated voter, and everyone who's here tonight and everyone who's watching at home has taken an awesome step towards making sure that you're going to the polls with information. And I'm really sorry we couldn't answer everyone's questions tonight. I hope that you will read the full reports that the students wrote and take a look at the work that they put in. It's a big obligation and a big responsibility that we all bear. But I thank you all for participating and being here, and I thank our students for their hard work. Thank you very much.